Welcome back to another incredible story that proves sometimes the most powerful lessons come from unexpected places. Before we begin, comment where you're watching from today. Now, let's dive into a tale that shocked America's legal community and reminded us all about the true meaning of religious freedom. In the marble-columned halls of Cincinnati's most prestigious law firm, where polished shoes clicked against immaculate floors and success was measured in billable hours, Usha Vance stood out not for her impressive credentials or her role as managing partner, but for the simple silver cross that hung from her neck. It was a family heirloom, passed down through generations, a symbol of both her Christian faith and her Indian-American heritage. While other attorneys adorned themselves with designer brands and status symbols, Usha's most treasured possession was this humble reminder of her family's journey. The trouble began on a brisk October morning when Judge Eleanor Blackwood swept into the courthouse for what should have been a routine pretrial conference. As the newly appointed head of the district court's Professional Standards Committee, she had made it her personal mission to enforce what she called absolute neutrality in all legal proceedings, including an aggressive stance against any religious symbols in the courtroom. Judge Blackwood's reputation preceded her, a hardline secularist who believed that religious expression had no place in the legal profession, regardless of the Constitution's guarantees. Her sharp eyes narrowed as they fell on Usha's cross, glinting in the fluorescent light as the young attorney prepared her arguments. The judge had been waiting for such an opportunity, a chance to make an example of someone prominent enough to send a message. "Ms. Vance," she declared, her voice carrying across the nearly empty courtroom, "that religious symbol violates our new courthouse guidelines on secular professional spaces. You'll need to remove it immediately or face a fine of $5,000 per day of non-compliance." The few other attorneys present looked up from their briefs, tension filling the air as they watched the scene unfold. But Usha didn't flinch. Years of facing subtle discrimination and overcoming barriers had taught her composure under pressure. Instead of arguing or becoming defensive, she calmly closed her legal pad and met the judge's stern gaze. "Your Honor," she said, her voice steady and clear, "I believe you might want to review the recent Supreme Court decision in Kennedy v. Bremerton School District before enforcing that guideline." Judge Blackwood's condescending smile flickered slightly. She hadn't expected such a direct challenge, let alone one citing relevant legal precedent. But she pressed on, determined to maintain control. "This is a matter of maintaining the appearance of neutrality in our courts, Ms. Vance. Your position at your firm doesn't exempt you from these rules." The courtroom had grown completely silent now, every eye fixed on the unfolding confrontation. Usha reached into her briefcase and pulled out a leather-bound copy of the Constitution. "You're right about one thing, Your Honor," she replied, her voice remaining respectful but firm. "My position doesn't exempt me from rules. But the First Amendment does protect my right to religious expression, as long as it doesn't disrupt judicial proceedings." Judge Blackwood's face flushed red as Usha continued, expertly laying out the legal framework that protected her right to wear the cross. She cited not only Kennedy v. Bremerton but also several other landmark cases that dealt with religious expression in professional settings, her command of constitutional law becoming more impressive with each citation. Word of the confrontation spread through the courthouse like wildfire. Other attorneys began slipping into the courtroom, some discreetly recording, others quickly researching the cases Usha mentioned. The judge found herself in an increasingly uncomfortable position as she realized that this young attorney wasn't just name-dropping cases, she understood their implications deeply. Furthermore, Usha added, her voice gaining strength but never losing its respectful tone, "The Religious Freedom Restoration Act requires that any government restriction on religious expression must be the least restrictive means of achieving a compelling government interest. I'm curious, Your Honor, what compelling interest is served by fining an attorney for wearing a family heirloom that carries religious significance?" The judge's authority was crumbling with each well-reasoned argument. She hadn't expected to encounter an attorney who had not only studied constitutional law at Yale but had also argued religious freedom cases before the Supreme Court. More than that, Usha's calm demeanor and articulate defense were making the judge's aggressive approach look increasingly unreasonable. Other attorneys began discreetly displaying their own religious symbols, crosses, stars of David, Islamic crescents, and other sacred items that they had previously kept hidden out of fear of similar confrontations. The courtroom was becoming a silent demonstration of solidarity and religious freedom. Judge Blackwood attempted one final assertion of authority. The committee's guidelines are clear about religious symbols in legal proceedings. This isn't about constitutional rights, it's about maintaining professional standards. Usha opened her constitution to Article 6 and began reading aloud, "No religious test shall ever be required as a qualification to any office or public trust under the United States." She looked up at the judge. This principle has been consistently applied by the Supreme Court to protect religious expression in professional settings, including courtrooms. The judge's face had gone from red to pale as she realized the full extent of her miscalculation. Not only was she on shaky legal ground, but she was creating a public relations nightmare. Several attorneys had their phones out now, and she could already imagine the headlines. Judge attempts to fine leading attorney for religious expression, gets lesson in constitutional law. What made the situation even more powerful was Usha's continued composure. She never raised her voice, never became confrontational. Instead, she demonstrated a deep understanding of the law while maintaining the utmost respect for the judge's position, if not her interpretation of the law. As murmurs spread through the courtroom, a senior member of the bar finally stepped forward. James Sullivan, a respected constitutional scholar, had been watching the exchange with growing interest. "Your Honor," he interjected gently, "I believe Ms. Vance has raised several valid legal points that merit careful consideration. Perhaps we should continue this discussion in chambers, where we can review the relevant precedents more thoroughly." The offer was a diplomatic lifeline, giving Judge Blackwood a chance to retreat without further damaging her reputation. But before she could accept, Usha made one final statement that would be quoted in legal textbooks for years to come. "Your Honor, the Founding Fathers understood that religious freedom doesn't mean freedom from religion, it means freedom of religion. They designed our Constitution to protect both believers and non-believers, ensuring that no one would face discrimination or punishment for their faith or lack thereof. I wear this cross not to promote my religion or impose it on others, but as a personal expression of my beliefs and heritage. If we start fining attorneys for such personal expressions of faith, we're not protecting secular spaces, we're violating the very principles our legal system was founded upon." The courtroom erupted in quiet applause, quickly hushed by the bailiff's stern look, but the message was clear. Judge Blackwood had no choice but to withdraw her threat of a fine, though she did so with visible reluctance. "I will review the relevant precedents," she managed to say, before making a hasty exit. As she left, attorneys gathered around Usha, not to congratulate her on her victory, but to thank her for standing up for everyone's right to religious expression. Jewish lawyers showed her their Star of David necklaces, Muslim attorneys displayed their modest hijabs, and others revealed the religious symbols they had been afraid to wear openly. In that moment, what could have been a story about privilege and power became something far more meaningful, a reminder that religious freedom is a cornerstone of American democracy, and that sometimes it takes a young attorney's clear-eyed understanding of constitutional principles to remind the judiciary of this fundamental truth. Have you ever had to stand up for your beliefs in the face of authority? Share your story in the comments below. In our next chapter, we'll see how this confrontation sparked a nationwide conversation about religious freedom in the legal profession and the importance of knowing your rights. Don't forget to like and subscribe to catch the next part of this incredible story. Welcome back to our continuing story about how one attorney's stand for religious freedom became a catalyst for change. If you haven't watched Chapter 1, make sure to check it out first. And don't forget to comment where you're watching from today. The morning after Usha Vance's encounter with Judge Eleanor Blackwood, the Cincinnati legal community was buzzing with anticipation. Video clips of the courtroom confrontation had spread through legal circles overnight, igniting fierce debates about religious expression in the judiciary. But while most attorneys might have reveled in their viral moment, Usha arrived at the courthouse just as she always did, composed, prepared, and wearing her grandmother's silver cross. Judge Blackwood, however, was not ready to concede defeat. Having spent the night reviewing legal precedents and consulting with her allies on the Professional Standards Committee, She arrived at her chambers determined to find a way to reassert her authority. The judge had built her career on being tough and uncompromising, and she wasn't about to let a young attorney, even one with Usha's credentials, undermine her vision for secular courts. By mid-morning, she had issued an emergency amendment to the courthouse guidelines, attempting to circumvent the religious freedom protections by reclassifying certain religious symbols as potentially prejudicial accessories in legal proceedings. The amendment was carefully worded to appear neutral, but its timing and specific provisions made its true target clear. What the judge hadn't counted on was the response from the legal community. As news of the amendment spread, attorneys of various faiths began organizing. David Goldstein, president of the Jewish Bar Association, coordinated with Amira Rahman from the Muslim Lawyers Alliance and other religious and secular legal groups to form the Coalition for Religious Expression in Law, CRL. Usha found herself at the center of this movement, not because she sought the spotlight, but because her calm, legally sound defense of religious freedom had provided a template for others to follow. During lunch break, attorneys gathered in the law library to share their own stories of religious discrimination and to study the constitutional principles that protected their rights. The scene was remarkable, lawyers of different faiths sitting together, comparing notes on Supreme Court decisions, and helping each other understand the complex interplay between religious freedom and professional conduct. Usha moved quietly among them, offering insights from her years of constitutional law practice, but never attempting to dominate the conversation. Judge Blackwood observed this gathering from her chamber's window with growing concern. She had expected her amendment to quell the rebellion, but instead, it had sparked something far more powerful, a legal movement grounded in constitutional principles and united across religious lines. Her phone was ringing constantly now, with calls from media outlets, civil rights organizations, and concerned bar associations. The situation escalated when James Sullivan, the constitutional scholar who had witnessed the original confrontation, announced he would be filing an amicus brief challenging the amended guidelines. The brief was entirely within his rights, but its timing sent a clear message about where the legal establishment stood on the issue. Judge Blackwood decided to make one final attempt to assert control. She scheduled a special hearing for the following morning, where she planned to explain the legal basis for her guidelines and the importance of maintaining secular courts. Her clerks worked through the night preparing arguments they believed would justify the restrictions on religious expression. What happened at that hearing would become legendary in legal circles. As Judge Blackwood approached the bench, she found herself facing a courtroom filled with attorneys wearing various religious symbols, not just crosses, but crescents, stars of David, cicadas, and other faith symbols. Even non-religious attorneys wore symbols in solidarity with their colleagues. The judge began her prepared statement about the importance of maintaining secular spaces, but she was unprepared for what came next. Usha Vance stood up, and the courtroom fell silent. "Your Honor," she said, her voice carrying clearly through the hall, "would you be willing to engage in a respectful debate about the constitutional implications of your guidelines?" Judge Blackwood hesitated. Refusing would make her appear afraid of defending her position, but accepting meant engaging in a public debate with an attorney who had already demonstrated a remarkable grasp of constitutional law. After a moment's pause, she agreed, perhaps hoping to put the young lawyer in her place. What followed was a masterclass in constitutional debate. Usha began by acknowledging the importance of maintaining impartial courts, showing she understood the core concern behind the judge's guidelines. But then she systematically dismantled the legal basis for the restrictions, citing case after case where courts had upheld religious expression rights. "The Supreme Court has consistently held," she explained, "that religious expression is protected not just in private life but in professional settings as well. This principle, established through numerous decisions, recognizes that faith is an integral part of many people's identities, not something that can be checked at the courthouse door." As Usha spoke, other attorneys began contributing to the discussion. David Goldstein cited specific provisions of the Religious Freedom Restoration Act, while Amira Rahman discussed how the guidelines would disproportionately affect attorneys whose religious expression was more visible, such as Muslim lawyers wearing hijabs or Sikh attorneys wearing turbans. The debate reached its climax when Usha presented a legal analysis she had prepared overnight. She demonstrated how the judge's amended guidelines, far from being neutral, actually constituted targeted religious discrimination under established Supreme Court precedents. Her argument was so compelling that even the judge's own clerks were seen nodding in agreement. "Your Honor," Usha concluded, "the First Amendment doesn't just protect religious freedom as an abstract concept, it protects the practical expression of that freedom in our daily lives, including our professional lives. When we start creating arbitrary distinctions between acceptable and unacceptable religious expression, we're not promoting neutrality, we're engaging in the very kind of religious discrimination our Constitution was designed to prevent." The courtroom erupted in respectful applause, but what happened next surprised everyone. Judge Blackwood, instead of becoming defensive, did something remarkable. She listened. As the applause died down, she remained silent for a long moment, looking out at the sea of faces before her, each wearing their faith proudly and openly. "Perhaps," she finally said, her voice carrying a note of humility that few had ever heard before, "I have been so focused on protecting secular spaces that I forgot what we're really here to protect: the right of every person to be themselves, to practice law, and to serve justice without having to hide their identity or beliefs." The tension in the courtroom began to dissolve as Judge Blackwood continued. "Ms. Vance and her colleagues have demonstrated something important today, that the best way to protect everyone's rights is not by restricting religious expression, but by creating an environment where all beliefs, including the choice not to believe, are respected and protected." As the hearing concluded, attorneys and court staff alike realized they had witnessed something extraordinary, not just a debate about religious freedom, but a demonstration of how constitutional principles could bring people together across religious and ideological lines. The Coalition for Religious Expression in Law had achieved its first victory, but more challenges lay ahead. Before leaving the bench, Judge Blackwood made one final announcement that left everyone stunned. She would be establishing an attorney-led committee to help review and revise the court's guidelines on religious expression, ensuring that they protected both religious freedom and judicial integrity. And she wanted Usha Vance to serve as one of its founding members. Have you ever seen someone change their mind when presented with a compelling argument? Share your experiences in the comments below. In our next chapter, we'll see how this local victory sparked a national movement for religious freedom in the legal profession. Don't forget to like and subscribe to catch the next part of this incredible story. Welcome back to our continuing story of how one attorney's stand for religious freedom transformed into a national movement. If you're just joining us, make sure to watch chapters 1 and 2 first. And don't forget to let us know where you're watching from today. Just as the dust seemed to be settling in Cincinnati's courthouse, a new challenge emerged that would test the limits of religious freedom in the legal profession across the nation. The incident had caught the attention of Senator Marcus Whitfield, chairman of the Senate Judiciary Committee, who saw an opportunity to push through his controversial Judicial Neutrality Act, a piece of legislation that would effectively ban all religious expression in federal courts. The morning the news broke about the proposed legislation, Usha Vance arrived at her law firm to find reporters camped outside the building. The story had evolved beyond a local dispute into a national debate about the intersection of religious freedom, professional conduct, and constitutional rights. But while others might have been overwhelmed by the attention, Usha remained focused on the legal implications of the proposed law. During her lunch break, she gathered with the Coalition for Religious Expression in Law in the firm's conference room. The group had grown significantly since its formation, now including attorneys from dozens of jurisdictions across the country. David Goldstein, still wearing his Star of David proudly, pulled up the full text of the proposed legislation on the conference room screen. "They're trying to frame this as a protection of judicial neutrality," Amira Rahman observed, adjusting her hijab, "but the language here effectively criminalizes any form of religious expression in legal settings." The attorneys had become remarkably adept at constitutional analysis over the past few weeks, thanks in part to their continued study sessions with James Sullivan. Usha sat quietly, reviewing the bill's provisions with the same careful attention she'd given to Supreme Court decisions. After several minutes, she looked up. "This isn't just unconstitutional," she said, her voice carrying the weight of certainty. "It's a direct challenge to the very principles of religious freedom established by the First Amendment." The coalition quickly organized a virtual conference connecting legal groups from courts across the country. What started as a local movement was transforming into a national alliance. Attorneys from different faiths, backgrounds, and political beliefs united around a common cause, protecting their constitutional right to religious expression. Senator Whitfield, however, was not easily deterred. He scheduled a series of public hearings on the bill, carefully selecting witnesses who would support his position. What he didn't expect was the grassroots response organized by the legal coalition. Thousands of attorneys across the country began submitting testimony about how religious expression had positively impacted their legal practice. The turning point came when Usha was invited to testify before the Senate Judiciary Committee. The hearing room was packed as she approached the podium, her grandmother's cross visible against her navy blue suit. Cameras clicked and reporters leaned forward, eager to capture every word of her testimony. "Distinguished senators," Usha began, her voice steady and clear, "I stand before you not just as an attorney, but as an American deeply concerned about the future of religious freedom in our nation's courts. The proposed Judicial Neutrality Act, while well-intentioned, represents a fundamental misunderstanding of both the First Amendment and the role of religious expression in the legal profession." She proceeded to present a detailed legal analysis that left even seasoned legislators impressed. Drawing from historical documents, Supreme Court decisions, and constitutional scholarship, Usha demonstrated how the proposed law would violate not only the Free Exercise Clause but also the Establishment Clause by effectively showing government hostility toward religion. "The Supreme Court has repeatedly held," she explained, "that the First Amendment requires neutrality toward religion, not hostility. This bill, by attempting to eliminate all religious expression from legal settings, crosses the line from neutrality into active suppression of religious freedom." Senator Whitfield, known for his aggressive questioning of witnesses, attempted to challenge Usha's analysis. "Ms. Vance," he said, his tone condescending, "surely you understand that we're trying to protect litigants from religious bias. This isn't about suppressing freedom. It's about ensuring every person feels comfortable in our courts." Usha's response would later be quoted in law review articles across the country. "Senator," she replied, "creating an environment where people feel comfortable doesn't require stripping attorneys of their constitutional rights. True comfort comes from knowing that our differences are protected, not prohibited. When we force legal professionals to hide their faith, we're not promoting neutrality, we're teaching them that their beliefs are something to be ashamed of." The hearing room fell silent as Usha continued. "The Founding Fathers understood that religious freedom isn't just about the right to believe, but the right to express and practice those beliefs. They didn't create the First Amendment to build a wall between faith and profession, but to ensure that neither would dominate or suppress the other." As the hearing progressed, other members of the coalition testified about their experiences. David Goldstein spoke about how his visible expression of Jewish faith had led to meaningful interfaith dialogues with clients and colleagues. Amira Rahman described how wearing her hijab had opened opportunities to educate others about Islam and combat stereotypes in the legal community. The impact of their testimony was immediate and profound. Social media exploded with support for the attorney movement, with the hashtag #MyFaithMyRight trending nationwide. Religious leaders from various faiths issued statements supporting the attorney's position, emphasizing the importance of protecting religious expression in professional settings. Judge Eleanor Blackwood, who had been following the hearings closely, made a surprise appearance on the second day of testimony. Her statement to the committee marked a complete reversal of her earlier position. "My attempt to restrict religious expression in court was not just legally flawed," she admitted, "it was fundamentally contrary to the principles of religious freedom that make our nation unique." The judge's testimony carried particular weight given her previous stance. She detailed how her interaction with Usha and the other attorneys had forced her to confront her own biases and reconsider her understanding of religious freedom in professional settings. "These legal professionals," she said, "have demonstrated a deeper understanding of constitutional principles than many of us on the bench." As the hearings concluded, Senator Whitfield found himself in an increasingly isolated position. The attorney coalition had effectively demonstrated how the proposed law would violate constitutional rights while offering no meaningful benefits to judicial impartiality or client representation. More importantly, they had shown how religious expression, when properly protected, could enhance rather than hinder the practice of law. The story took an unexpected turn when several members of the Senate Judiciary Committee announced they would not support the Judicial Neutrality Act. Instead, they proposed working with the attorney coalition to develop guidelines that would protect both religious freedom and professional integrity. Usha's role in this victory was significant, but what made the story truly remarkable was how she had helped transform a personal stand for religious freedom into a nationwide movement for constitutional rights. The coalition she helped inspire had demonstrated that attorneys could be powerful advocates for their rights while respecting the complex balance between religious freedom and professional responsibilities. Have you ever been part of a movement that started small but grew into something bigger? Share your experiences in the comments below. In our next chapter, we'll see how this victory led to lasting changes in how courts across the country approach religious freedom. Don't forget to like and subscribe to catch the conclusion of this incredible story. Welcome back to the final chapter of our story about how a simple silver cross sparked a national movement for religious freedom in the legal profession. If you're just joining us, make sure to watch the first 3 chapters. And as always, let us know where you're watching from today. 6 months had passed since the Senate hearings, and the landscape of religious freedom in American law had transformed dramatically. The defeated Judicial Neutrality Act had given way to something far more significant, the Legal Professional Religious Freedom Protection Act, a bipartisan bill crafted with input from the Coalition for Religious Expression in Law and constitutional experts across the country. On a bright spring morning, Usha Vance stood in the Rose Garden, surrounded by attorneys of various faiths from across the nation. Her grandmother's silver cross caught the morning light as she prepared to witness the signing of the new law. The journey that had begun with a confrontation in a Cincinnati courtroom had led to this historic moment. But even as celebration filled the air, a new challenge emerged that would test the limits of the coalition's victory. Professor Victor Reynolds, a prominent legal scholar, published a controversial paper arguing that the new law would undermine judicial impartiality and professional standards. His argument gained traction among certain academic circles, threatening to undo months of progress. Rather than responding defensively, Usha and the coalition saw an opportunity to demonstrate the practical benefits of protected religious expression in law. They organized a nationwide series of faith and justice forums, where legal professionals from different religious backgrounds shared how their faith informed their practice while respecting professional ethics and client interests. At the first forum, held at the Cincinnati courthouse where it all began, something remarkable happened. Professor Reynolds himself attended, initially skeptical but willing to observe. The event opened with a panel discussion featuring attorneys from various faith traditions, including David Goldstein, Amir Rahman, and others who had been part of the original coalition. What we've created, Usha explained to the packed courtroom, isn't just about protecting religious symbols or expressions. It's about fostering an environment where legal professionals can bring their whole selves to their practice. When we don't have to hide who we are or what we believe, we can focus more fully on serving justice. Professor Reynolds listened as attorney after attorney shared their experiences. A Sikh lawyer described how explaining his turban to clients had improved his ability to build trust and understanding. A Buddhist attorney talked about how her meditation practices had enhanced her negotiation skills. A secular humanist lawyer spoke about how understanding various religious perspectives had improved his ability to represent diverse clients. The impact of these testimonies was visible on Professor Reynolds's face. During the question and answer session, he stood up. "I came here today," he admitted, believing that religious expression would compromise professional objectivity. "What I've witnessed instead is how it can enhance it when properly protected and respected." This public conversion of a prominent critic added significant credibility to the coalition's cause. But the real test of their success would come in the practical implementation of the new law across thousands of courtrooms nationwide. Usha and the coalition worked tirelessly to develop implementation guidelines that would help courts strike the right balance. Judge Eleanor Blackwood, who had become one of the movement's strongest allies, played a crucial role in this phase. She traveled to courthouses across the country, sharing her own journey from opposition to understanding. The beauty of our Constitution, she would explain, is that it protects both freedom of religion and freedom from religion. These attorneys have shown us how to honor both principles simultaneously. The coalition's work caught the attention of international legal communities as well. Delegations from other countries began visiting American courts to observe how religious freedom could be protected while maintaining professional standards. Usha found herself explaining American constitutional principles to legal professionals from across the globe. One particularly moving moment came when a group of attorneys from a country with strict restrictions on religious expression visited Cincinnati's courthouse. They were amazed to see lawyers of different faiths practicing together, their religious symbols visible but not disruptive, their differences enriching rather than dividing the legal community. In America, Usha explained to them, "We believe that true justice isn't just about applying the law, it's about understanding the human experience in all its diversity. And for many people, faith is an integral part of who they are. When we protect religious freedom in legal settings, we're not just upholding constitutional rights, we're creating better advocates for justice." The success of the implementation became evident in unexpected ways. Courts reported improved client satisfaction, reduced religious-based discrimination claims, and increased diversity in the legal profession. The freedom to express religious identity had created an atmosphere of mutual respect and understanding that extended beyond religious matters. James Sullivan, the constitutional scholar who had supported the movement from its beginning, developed a new curriculum unit on religious freedom that was adopted by law schools nationwide. "What these attorneys have taught us," he wrote in the introduction, "is that constitutional rights aren't just abstract concepts to be debated, they're living principles that shape our professional lives." As the year drew to a close, Usha organized one final event, a national conference where legal professionals could share how the movement had impacted their practice. The stories shared that day revealed the profound impact of protected religious expression on American jurisprudence. One attorney described how the freedom to wear her hijab proudly had given her the confidence to take on more challenging cases. Another explained how discussions about different faith traditions had improved his ability to serve diverse communities. A third shared how the movement had inspired her to specialize in constitutional law. Judge Blackwood, speaking at the conference, reflected on how far they had come. "When I first confronted Usha about her cross," she said, "I thought I was protecting judicial neutrality. What I've learned since then is that true neutrality requires protecting everyone's rights to be themselves, including their right to express their faith." The conference concluded with a surprise announcement. The American Bar Association had decided to establish a Religious Freedom and Professional Ethics Commission with representatives from different faith backgrounds to ensure that religious freedom in the legal profession continued to be protected and respected. Usha was asked to serve as its first chairperson. But perhaps the most powerful moment came when Usha stood to make her final remarks. She touched the silver cross at her neck, the symbol that had started it all, and addressed the gathered legal professionals, judges, and supporters. "This journey began with a simple question of religious freedom," she said, "but it's become something much more. We've shown that when we stand up for constitutional rights, we're not just protecting ourselves, we're protecting everyone's right to practice law authentically and serve justice fully. The Constitution isn't just a document we cite in briefs, it's a living guarantee of our freedoms, and it's up to each generation of legal professionals to understand and protect it." As the applause filled the conference hall, those present understood that they had been part of something historic, not just a victory for religious freedom, but a demonstration of how legal professionals could lead the way in protecting constitutional rights and creating positive change. Have you ever stood up for something you believed in and seen it make a bigger difference than you expected? Share your stories in the comments below. And don't forget to like and subscribe to hear more inspiring stories about people making a difference in the world. This has been the story of how one attorney's stand for religious freedom transformed American law. But in many ways, it's really the story of how the Constitution's promises can come alive when people have the courage to stand up for their rights and the wisdom to do so with respect and understanding. Thank you for joining us on this journey. Until next time, Remember that every great change starts with someone willing to stand up for what's right.